Andrea Saldarriaga, and I'm a fellow with the Vale Columbia Center from the University of Columbia, New York. And I lead the Investment and Human Rights Project at the London School of Economics. And I'd like to give you a warm welcome to this thematic session on And before getting to the substance of today's discussion, I'd like to briefly outline the procedures we will follow today to ensure we have an open, constructive, and respectful atmosphere for our debate. So these will be our ground rules. First, and as you may know already, there are designated microphones for the different categories of stakeholders, and I would please ask you to use these microphones that are on the front of the room. Second, when thinking about your interventions, please avoid prepared written statements. Those statements are very welcome in the website of the forum, but today we want to engage in a interactive discussion, and we invite you to contribute to a constructive dialogue today. And finally, since we have a tight schedule, thank you, and we would like to hear from as many of you as possible, we would ask you to keep your intervention short, so no more than 2 minutes. And the last thing is that for the interpreters, I would like to ask our panelists, commentators, and those speaking from the floor to speak slowly so that they can translate properly your interventions. This session is going to be translated, and we have Spanish speakers, so there's going to be simultaneous translation. So now, let's turn to the content of this panel. So what are we focusing on today? So we are focusing on investment contracts, that is, contracts that are signed between investors and states. And we are focusing on investment treaties. These are agreements signed between states to protect foreign investment, and that under certain circumstances can be enforced by foreign investors through international arbitral tribunals. The relevance of both investment treaties and investment contracts was recognized early on during the mandate of John Ruggie, and a number of challenges were also identified through, for example, the landmark study on stabilization clauses that was conducted with the IFC, the International Finance Corporation. And the question was then how to integrate the state duty to protect and the corporate responsibility to protect in the area of investment in order to overcome these challenges that were identified during the work of the mandate. So to assist states, principles 8 and 9 of the guiding principles invite governments to strive on policy coherence when preparing investment policies, and they also require states to keep their policy space to meet the human rights obligations when they sign treaties and when they enter into investment contracts. Further, John Ruggie's team prepared the principles for responsible contracts to provide guidance to both states and investors, negotiators, for managing human rights risk in the context of investment projects. So where are we today? So after 2.5 years after the endorsement of the guiding principles, what we see is that the flurry of activity surrounding the implementation of the principles has only tangentially touched upon the question and the area of investment. So what we want to do today with this session is to bring this area to your attention, and to do so we have invited these prominent panelists and commentators to tell us about and to discuss how human rights are relevant in the context of investment and what the role of the guiding principles and the principles for responsible contracts could be in this context. So we have invited, to my left, we have Renato Torres. Renato is former Director of Analysis and monitoring of investment from the Ecuadorian government. We have invited Viviane Schiavi. She is the Senior Policy Manager on Corporate Social Responsibility and Anti-Corruption at the ICC, the International Chamber of Commerce, which is the association that groups businesses worldwide. And contributing his thoughts from as a practitioner in arbitration, we have invited Zachary Douglas. Zachary is a professor at the Geneva Institute, and he's also a barrister with Matrix Chambers, and he combined a very interesting experience of being counsel to both investors and states, and also as arbitrator. And they will address the question of how human rights have emerged in their in the context of their work in investment, and what challenges does this pose to their work. And then I will invite them to provide, and Elisabeth is the Officer-in-Chief of the Treaty Division of the UN Conference on Trade and Development, and her work focuses on assisting developing countries to participate as effectively as possible in international investment policy making. Samuel and Elisabeth, they will have each 5 minutes to comment on the panelists' experiences, and I again will be strict, as what we want to do is to engage with the audience after the interventions. If you want more information about our panelists, you find their bios in the table at the entrance of the room. And without further ado, I will pass it on to Renato Torres. Renato.
Gracias, Andrea.
Thank you very much, Andrea. Good morning, everybody. First of all, I'd like to congratulate the organisers of the event for the success here, and also for the panelists for their focus, which I think is going to be quite different in terms of this issue, which is human rights and investment instruments. So first of all, I just wanted to talk about my approach here with this presentation, which is a bit more practical as opposed to academic. And now I'm a public official in Ecuador, and for 2 years I worked developing investment instruments, and I also worked on the Ecuadorian version, or the alternative version, faced with bilateral protection policies, and also I've been working on the investment policy of Ecuador. So my focus is not academic, but has been built up through professional training as that were negotiation and preparing of investment instruments. So I think this is a little bit different, because we're also dealing here with the guiding principles for businesses of John Ruggie. So this doesn't only lead to theoretical discussion or academic discussion, but also has a bearing on direct application and practical aspects, and how these can be used effectively in reality. So this experience in drawing up investment contracts and working in investment in Ecuador has allowed us to analyze what things can be done in terms of investment instruments, what the shortcomings are of these aspects that have been identified, and what can be corrected or improved on. So first of all, I just wanted to tell you about the Ecuadorian context before going on to look at the shortcomings and the specific investment instruments in Ecuador. Now, as a basic context, I wanted to mention that this is a very sensitive issue in Ecuador, not only because of the participation that foreign direct investment has in our economy, but also because of Ecuador's difficult experience in terms of signing more than 20 bilateral treaties, indeed 23 in total. And also there are 19 current procedures taking place in terms of arbitrage. And these often run to $2 billion. And there are demands of 2 companies asking for several $1 billion. So for this reason, investment is a very sensitive issue in the country, and the government has been trying to deal with this as best possible.
Una vez trabajado 2 años en la Agencia Ecuatoriana de Inversiones y haber suscrito más de 10 contratos de inversión, contratos que van desde $1 millón hasta 2.000 millones de dólares, y tenido decenas de reuniones con inversionistas privados. ¿Cuáles han sido los aciertos que hemos encontrado? ¿Cuáles son las cosas que sí se pueden hacer, los temas que sí se pueden incorporar en la práctica, en los contratos de inversión, en las políticas de inversión? Por ejemplo, a través de los contratos de inversión, que son una figura que sirve para estabilizar ciertos incentivos tributarios y brindar protecciones adicionales a los inversionistas, hemos creado un instrumento de regulación y de protección a la inversión propio que se alinea a los objetivos y prioridades nacionales, es decir, rompe con el esquema de los tratados bilaterales de inversión firmados en los 90, que sobre todo obedecen a un formato predeterminado por los estados, sobre todo exportadores de capital. Los contratos de inversión suscritos han demostrado que sí se pueden generar instrumentos más balanceados en derechos y obligaciones. Son contratos supervisables, preservan el espacio regulatorio del Estado, eso es importantísimo, dan estabilidad tributaria específica, incluyen requisitos de desempeño, y a pesar de que en un inicio muchos pensaban que no se iban a firmar contratos de inversión, es decir, un inversionista privado, un inversionista extranjero, siempre va a preferir una protección más amplia. La práctica nos ha dado la razón. Hay, como les decía, 10 contratos suscritos, y es un ejemplo de las cosas que se pueden hacer y que se pueden cambiar sobre el status quo. Ahora bien, yendo al tema central del panel, ¿cuál ha sido el nivel de incorporación de los derechos humanos en dichos instrumentos? Lamentablemente, comentaba con los panelistas que no se han incorporado hasta la fecha temas de derechos humanos en los contratos de inversión, en los instrumentos de inversión, ni referencias específicas a instrumentos internacionalmente reconocidos. ¿Cuáles son las razones? Esos contratos han sido trabajados por varias carteras de Estado, alrededor de 20 carteras de Estado de diferentes ámbitos tributarios, desde el punto de vista de políticas públicas, etcétera. ¿Y por qué no se han incluido los temas de los contratos? Bueno, pienso que primeramente no se incluyeron temas de derechos humanos de los instrumentos de inversión ecuatorianos porque no se conocían, no los conocíamos. En segundo término, yo pienso que el Estado ecuatoriano a partir del 2008 tiene una nueva constitución con un carácter garantista que ha conseguido muchísimos logros en el campo.
Achieved a great deal of success in the social arena and also in terms of labor, disabilities and so on. And so because of this, support has been given to contracts which are in line with the Constitution more than internationally speaking. Now, the Ruggie principles aren't sufficient. We also need to have this enshrined in our Constitution. Now, another reason that I think perhaps issues of human rights haven't been included in investment contracts and Ecuadorian investment instruments is because based on such a complicated experience in terms of having these investment assets, we've also seen amounts of up to $11 billion involved, and this has meant that we need more balanced instruments. What we need to do is to develop preventive strategies if we are to avoid conflict or problems in the future. So the focus in international, or rather the focus in Ecuador has been defensive in the past and hasn't sufficiently taken into account human rights. So what shortcomings have we detected and what challenges remain that must be corrected in terms of investment contracts and human rights? Well, first of all, I think it should be clear that investment contracts and investment policies have had, moreover, a sectoral approach. They're approved or indeed validated by a council that is made up of around 20 different state departments, and all these have an approach based on productivity and technology transfer. But on this council, there's no specific one that deals with human rights. So what would be the challenge, the general challenge in terms of all these contracts and with human rights? So that's independently from the type of contract that's given. There needs to be some kind of basic guideline, a cross-cutting guideline. There are around 30 different state departments and 28 public companies. So we need to make sure that they're all aware of human rights and at least are aware of this cross-cutting policy. So another challenge is the issue of training in human rights or capacity building. We need to make this institutional, I think, in Ecuador. Now, in Latin America, there's a great deal of turnover in terms of staff in public official positions. And so what we also need to make sure that we have is supervision, follow-up of standards and policies, and also to ensure that treaties and agreements are applied properly on the ground, and that they translate indeed into practice. Now, once we've looked at the weaknesses of the system, what might be our general conclusions based on this practical experience in Ecuador, in including or not reference to human rights in investment instruments? Well, we think it's imperative to have better institutional coordination, better training, and better capacity building for all public officials, whether these be institutionally or not. And we also need to work a great deal on how to implement these instruments and also how to incorporate human rights into them. To conclude, we believe that we need also to work on the short term in terms of already applying, as soon as we can, human rights issues within investment instruments. This is doable and can be done immediately. It's an upcoming issue which can already be applied, I think, but also we need to work in the long term. As Ecuador's mentioned on various occasions, we need to work on a multilateral binding instrument. Now, these two issues can be worked on at the same time. They're not mutually exclusive. Now, another very important issue that's come up is the importance of working on formal issues within investment instruments. Now, quite often, much work has been done on policies and harmonization, but we also need to look at the wording of this and the scope of definitions. And also in terms of dispute resolution, we also need to look at how this can be achieved substantially. Now, finally, with regard to the guiding principles on business and human rights, I think that it is a great progress and should be built upon, but it doesn't mean that we mustn't in the future work on legally binding instruments. Thank you very much.
Thank you, Renato. And now invite Viviane to take the floor. Thank you.
I'd like to thank the UN Working Group and Andrea for inviting me to be part of the panel today. I'm honored to be here. I represent the International Chamber of Commerce, ICC. ICC is the world's largest and most representative business organization. We represent thousands of companies from all sectors in every part of the world. The main aim of ICC is to promote open international trade and investment, and to help business meet the challenges and opportunities of globalization. ICC is a firm believer that open exchanges in trade and investment is a positive force for growth and development and for the betterment of people's lives. ICC has three main activities: rule setting, dispute resolution, and policy advocacy. ICC's International Court of Arbitration is the world's leading institution for arbitration. On policy, business leaders and experts drawn from the ICC membership develop advocacy and business tools on a range of areas, from corporate responsibility and anti-corruption to trade and investment policy, environment, intellectual property, and other areas. ICC works closely with the United Nations, the WTO, and other intergovernmental fora such as the G20. We have a robust program in business ethics that promotes corporate responsibility and anti-corruption through advocacy and business tools. ICC's rules on combating corruption, first issued in '77 along with the FCPA, were the first rules by a global business organization for business by business on how to combat corruption. We now have a whole suite of anti-corruption tools, including guidelines for dealing with third parties, the ICC Anti-Corruption Clause, which is a clause to be included into private contracts between commercial parties whereby they commit to complying with the ICC rules on combating corruption, and an ICC Ethics and Compliance Training Handbook, which will actually be launched next week. In addition, the ICC Guide on Responsible Sourcing advises companies on how to integrate environmental and social considerations in the supply chain. ICC played a leading role in the development of the guiding principles on business and human rights, conveying business interests all along to the then draft principles being developed by Professor Ruggie. We always firmly conveyed businesses' commitment to the corporate responsibility, and also the need for a balanced approach, that the state duty to protect human rights is fundamental for business to be able to assume its responsibility in the area. ICC feels that right now a very important phase is the outreach, the communication on how to operationalize these principles for investment, for businesses and supply chains. The principles are fairly new. They were endorsed by the Human Rights Council 2 years ago. And the responsible contract work is also from 2 years ago. A lot of the work now is just communicating to companies, banks, investment firms that these guidelines and principles exist, and helping them operationalize them, helping them align their internal systems in terms of compliance with different standards, with the OECD MNE guidelines, with the ISO 26000 standard, and others. In terms of the subject of our panel today, integrating human rights and international investment, businesses and governments are keenly aware of the importance of investment as a driver of growth and development. ICC's investment guidelines, which are free and can be downloaded on the net, provide guidance for investors and governments alike for creating a more enabling environment for cross-border investment. And they set out shared responsibilities and opportunities for both governments and investors for fulfilling the opportunities of cross-border investment. These were just updated last year, updating guidelines from '72. And they note the sharp increase of international investment inflows to developing and transition economies, totaling now 52% of total investment inflows. The guidelines integrate the principles of the UN Guiding Principles for Human Rights, and they take heed of the UN work on responsible contracting, recommending that human rights risks be best avoided or mitigated if identified and managed from the start of international investment projects and agreements. There are new chapters in these guidelines that deal with elements of anti-corruption and corporate responsibility. The guidelines call on the investor to create shared value by developing business opportunities that contribute to the economic and environmental progress of the host country, to support sustainable economic growth, to respect the human rights of those affected by their activities, consistent with the UN Guiding Principles. The guidelines call on the investors, the government of the investor's country, to encourage the investor to contribute to the economic and social progress of the host country, to consider providing capacity building to help the host country establish the framework needed for environmental protection. The guidelines call on the government of the host country to consistently implement national laws to provide an operating environment that encourages responsible business conduct. to ensure access to courts, mediation, and arbitration, or other appropriate remedies so that disputes can be efficiently resolved, and to help companies operating in the jurisdiction to support the progress of the country. On the work on responsible contract, we're aware of ICC, of the very, very hard work put into that over a number of years. They are, as I said before, fairly new, these principles on how investment contracts are shaped, and it's hard to predict how they will be integrated in policies, but again, and contracts, it's early days. ICC encourages companies to take into account human rights considerations in their business ventures and agreements. And we welcome the pragmatic approach of human rights due diligence from the guiding principles. One thing I also want to add is that ICC is cooperating on a corporate survey that we sent to our thousands of member companies to not just assess uptake and implementation of the guiding principles, but also just frankly to communicate that they exist. And we are committed to continuing to work with the UN in this respect. And I think the aim of this very forum taking place this week is also part of the outreach. What my colleague Renato said is very true, is that capacity building, training is just very key at this point, both for states and for companies, and also for companies and firms to know how to align, again, compliance with the different standards. Last, Andrea, I want to say that companies and investment firms and banks need an enabling environment. As I heard in a panel yesterday, I couldn't help but agree. Companies sometimes have a sense that, they don't want to be in a position where human rights are being privatized. They need an enabling environment. Governments need to establish a conducive environment where banks and firms and companies can implement their responsibility to respect human rights. Yeah, I think I'll end there. Thank you.
Thank you, Viviane. And I'll now invite Professor Douglas.
Good morning, everyone. As I only have 7 minutes and we have a ruthless chairperson, I'm going to have to dispense with the mandate of trying to give you an overview of investment treaty arbitration and commercial arbitration as it affects human rights. That won't be possible. But what I thought I would do is provide you with an insider's view of how outsiders can influence outcomes and the development of international investment treaty law. Investment treaties do nothing really more than codify existing customary international law obligations, such as the prohibition against uncompensated expropriation. The revolution has come not necessarily in the codification of these obligations, but in the conferral of interpretive power over those obligations to private tribunals. The question for us is, what's the regulatory space which is carved out from these treaties to allow states to adopt measures to protect human rights and other public interest? That regulatory space is not defined by the tribunals, it's not defined by the treaties, so it's left up to the tribunals to do so through interpretation. And what I mean by a regulatory space, I mean a space in which the state doesn't have to buy back its right to regulate by paying full compensation to private parties affected by the regulatory measures. As I said, it's not defined by the treaty. So what I thought I'd share with you was the most cited definition of that regulatory space. And it's as follows. An uncompensated taking of property of an alien, or a deprivation of the use or enjoyment of property of an alien, which results from the execution of the tax laws, from a general change in the value of currency, from the action of the competent authorities of the state in the maintenance of public order, health, or morality, or from the valid exercise of belligerent rights, or is otherwise incidental to the normal operation of the laws of the state, shall not be considered wrongful. And then there's a few safeguards that are built in to make sure that the measure in question is a bona fide one. What you would have noticed immediately from that quotation is that there is no reference to human rights and there is no reference to the environment. Why is that? Because the quotation I just gave you comes from a Harvard draft convention which was put together by 2 Harvard law professors in 1961. That remains the most cited statement of the regulatory space which is carved out by investment treaties. Now, why is a fairly ancient document proving to be the most influential? The reason, I think, is that it is in a form and in a language which is readily adoptable by a judicial body. It's in a language and in a form which can be applied by a judicial tribunal. So I draw 2 insights from this, and here comes my advice on how outsiders can influence the outcomes. The first thing is that arguments about human rights protection need to be brought into the mainstream of public international law. The second point is that human rights needs to be operationalized within the foreign investment context. So turning to the first point, I guess what I'm getting at is that human rights cannot be presented to these tribunals as some form of lex specialis. If it's presented in that form, that it is too easy for tribunals to say, well, we're not a court that applies that lex specialis. We apply foreign investment law, we apply general principles of international law. So if you're presenting it as a lex specialis, that's beyond our jurisdictional reach. It reminds me of the metaphors that were used when the European Convention on Human Rights was incorporated into domestic law in England. And the metaphor was that we're going to bring human rights back home through the incorporation of the Convention through the Human Rights Act. It's almost like Britons were sent to Strasbourg with suitcases to load up their human rights, and then they could bring them back home into British territory. It's a very unfortunate metaphor. Human rights shouldn't be about the existence of something tangible in an instrument which can only be applied if there is jurisdiction over that particular instrument. Human rights are arguments about social ethics at the end of the day. So take the most common investment treaty obligation which is litigated, which says simply that investors shall be accorded fair and equitable treatment. Now, there's nothing in that formulation which is an affront to human rights protection in and of itself, fair and equitable treatment. So the moment we start rationalizing human rights arguments as exceptions to fair and equitable treatment, I think we're missing the point. There's no reason why fair and equitable treatment in and of itself inherently needs to contradict human rights standards. But the arguments need to be made, and the arguments need to be made more subtly. Take as an example the famous General Assembly resolutions procured by newly independent states, the resolution on the permanent sovereignty over natural resources of 1962, the resolution on the Charter of Economic Rights and Duties of States in 1974. Why was this so controversial? Why were there endless academic debates? Why was Western countries even sponsoring professors to go out and write reports to defend a particular position? Something which would almost be unheard of in the modern academic climate. The reason is that these arguments went to the heart of foreign investment law, the power of the state to expropriate, the principles which guided the amount of compensation that needed to be paid. These resolutions addressed those issues. Everyone, as a reason, got very worked up and excited about it. That's the way the human rights agenda, I think, needs to be presented. The second point, and the final point I want to make, is that human rights norms need to be operationalized. They need to come down from the stratosphere. They need to be put in a more concrete form. They can't be presented as mere abstractions. Moving away from investment law just for one moment, I had the privilege last week of representing the families of victims of the Batang Kali massacre, which was the massacre of 22 Chinese Malays in Malaya in 1948. One of the arguments we were raising before the Court of Appeal in England was that there was a customary international right to a proper and thorough investigation of an atrocity which approached a war crime. The question from the bench was an obvious one. Well, so say that we're in favour of recognising that customary international right. We had a truckload of materials evidencing the crystallisation of such a right as a matter of customary international law. But the next question was, well, what's the limitations of it? What's its scope? What does it cover? How far back does it go? And of course, customary international law doesn't provide concrete answers to these questions. It's exactly the same in foreign investment law. I remember I was rigorously criticized by some NGOs for not raising the right to water. In a particular case, I argued on behalf of the state. But again, this misses the complexity of the issues that arise. One cannot, as counsel, raise a red flag and say, well, this is all about the right to water, stop the case, dismiss the proceedings, and find in favor of the state. It can't work that way. The arguments need to be shaped in a way, just like the Harvard Convention that I read to you at the start of my brief presentation. They need to be shaped in a way which lend themselves to judicial application. That requires, I think, a lot more work in the specifics. How does a right to water operationalize itself within an investment treaty context when you're interpreting obligations such as the right to fair and equitable treatment? Thank you very much.
Thank you, Professor Douglas, and thank you to our panelists for sharing these very interesting experiences. And I'm now going to invite our commentators to share then their thoughts on our panelists' presentations. Samuel, you want to go? Thank you.
Thank you. Thank you, Mrs. Chair. I would like to start by saying thank you to you for inviting me here. I would have to admit that I've learned a lot in the 7 times 3 minutes that I've spent here, hearing the presentators. I think it was really useful. I would like to comment from the perspective where I come from. From an African point of view, the point of view of an African working with communities, and I would like to comment on to have 4 comments. My first comment is that we are talking about human rights, and I think we have to clearly distinguish between 2 things here: human rights and contract, human rights and investment policy. We have to distinguish between 2 things here very clearly. On one hand, most of the contracts I've seen so far are just by themselves a violation of international law, at least a violation of the state obligation to use the maximum of its resources for the benefit of the people, as clearly stated in the Covenant for Economic, Cultural, and Social Rights. So if the state had to comply with this covenant, all the contracts in natural resources that we have will have to be better contract, better balance in favor of the state. The states are gaining very little in the contracts that they have with investors. So to me, this is one of the most important human rights issues as far as investment is concerned. The second issue has to do with the content of the contract, what we have been discussing here. And there also, I think it's important to mention the fact that we are currently seeing some very disturbing trends. I will fully agree with the presenters who said there is nothing in the contract about protecting human rights, but we are more and more seeing things in the contract giving the right to violate human rights, and this is a concern, because when there's nothing said about protecting, sometimes the protection is not there, but when you really have a clear right to violate human rights, yes, then often the violation, not often, the violation is certainly there, will certainly come. This is a very concerning trend. Another issue that we are, and this is my 3rd comment, another issue we are currently witnessing is the fact that more and more in investment contracts, especially related to natural resources, the contract itself seems to become more and more an asset and not the physical asset, not the oil or the mineral that the contract is giving the right to have access to. But the contract itself is very often framed in such a way that one could very easily think, this is the deal, this is the stake, nothing else, nothing outside of the contract. Especially because of the type of rights that the companies are trying to have access to. And if you look at those rights, some of them you will say, but do you need this if you only want to have access to oil? And if you look at the the fact that in addition to the type of rights that are in the contracts, arbitration is very clearly an objective right from the beginning. And this happens in the last contract. The contracts I have been seeing in the past 4 or 5 years are more and more going towards this trend. So what to do? Before I say what to do, I would like to have a quick comment on this arbitration point. Many of the countries in Africa, I have been looking at their contract. Many of the countries do not know exactly what they are exposed to when they start signing contracts. And when arbitration comes in, okay, the contracts are designed to be secret. When the arbitration comes in, very often it's not public also. And when they lose, you don't have a lot of publicity if you lose. And very often they lose. So many people are not aware of the amount of money that the countries are losing because of poorly designed contracts. And I think this is a major problem also. How to move from here and how to use the guiding principles. I will fully agree with all what was said earlier. I think this is the way forward. We have the principle, but we have very little knowledge about the principle and about how to best use them, both in the countries and on the side of the investors going into those countries. Even if an investor really wants to do it, I don't think it's very clear how to do it, how to proceed. And I think we have to make it clear. Also, for the local NGOs and for the communities, they need to know that they have something that they can hold their government and the investors next to them accountable for. They have some rights, and there are at least two parties. The communities are third parties here in the contract, but the two parties in the contract have the very clear obligation to respect and protect the rights of the community, and I think they have to know it. So for me, the next step will be to make some outreach to the states, to the companies, and to the communities. This is key. We need also to have some test cases of very good company willing to start thinking about how to best implement the guidelines and partnering with one state, with local communities to see how this can happen, to be used as a pilot case from where a lot of lessons will be learned and some dissemination will be done after that. Thank you, Mrs. Chair.
Thank you, Samuel. And I'm now inviting Elisabeth for her comments.
Okay, thank you, Andrea. Thank you to the organizers of this panel this morning to have chosen to address an issue that is, I believe, really of fundamental importance. I'm from UNCTAD, United Nations Conference on Trade and Development, and what we do there is we try to help developing countries integrate beneficially in the global economy. And this issue of human rights and international investment and human rights and international investment treaties is really at the core of our mandate of our work as well. In UNCTAD, since the Doha conference, which shaped our intergovernmental mandate, we work on sustainable development and inclusive growth, and human rights really is a fundamental part of that. Even in our intergovernmental meetings, human rights are being mentioned in some of the provisions there. What we do in UNCTAD, besides technical assistance, research and analysis, and intergovernmental consensus building, is that we also try to look a bit at the big picture. And I was very happy that many of you picked up two documents I brought, our World Investment Report, that's our flagship, and our investment policy framework. That's one particular document that is relevant for our discussion here today. Let me try to sum up a bit like what the interventions said before me and try to link it all to one coherent storyline that also fits with the work of UNCTAD's investment division. I think we had a very interesting intervention by the International Chamber of Commerce, who pointed to the role of business and also of foreign direct investment in terms of addressing development challenges and in terms of addressing the importance of human rights in that context. That very much links also to the work of UNCTAD. In our World Investment Report, we regularly report on the numbers, the figures for foreign direct investment, and we try to link that to the development challenge. Last year also we looked at global value chains, supply chains, and I think our representative from ICC highlighted the importance of that. there are indeed human rights issues at the practical level of the interaction between businesses in their day-to-day conduct, and I think that's important to flag. However, the second point, and that's much more related to the work we are doing in my section, namely with respect to international investment agreements, I think that was a point being picked up by Renato, Zach, and also by our last commentator. Let me start here by Zachary, because Zachary mentioned, he talked about this international investment arbitrations. And again, let me do a bit of publicity. In this document here, you can find statistics, data, summary about the number of these international investment arbitrations. By now, we have more than 500 of these arbitrations. And as Zach mentioned, like human rights do have an implication there. So what we try to do is to monitor. And I think Zach pointed out this very important context of bringing human rights home to the investment treaty tribunals and the difficulty of shaping human rights arguments in a way that they are being picked up by the tribunals. So I think that's really an area that deserves a lot of future work. And I do believe that the guiding principles and the human rights framework as such really has a role to play there in a way of like working with two legal concepts and bringing them back together. Let me now also come to what Renato mentioned at the very beginning. He talked from the government perspective, and he talked about his country's international investment treaties. Here also, again, the last sort of like advertising. In our flagship publication, we give statistics about these international investment treaties. By now, there are more than 3,000 of these international investment treaties. They take very different forms and shapes. And as Renato pointed out, very few of them directly address human rights. We try to look a bit to what extent these treaties do look at issues related to human rights, and we see that some of the more modern ones indeed do already have some references to issues that also refer to human rights. So what now, and I think Renato mentioned the challenge of drafting these treaties, redrafting these treaties, informing treaty negotiators about like what can be done in this context. And I think that's where our other document comes in, the Investment Policy Framework for Sustainable Development. That's the sort of like thinner document I hope many of you picked up. And what we try to do there is give guidance to international treaty negotiators about how to formulate investment policies at the international and national level and how to make them work better for sustainable development. And in doing that, I think we also like really give avenues of where human rights ideas can slowly find their way into these international investment treaties. And maybe that also brings us to the point that Renato mentioned, that like first we have to build treaties that allow for the incorporation of human rights and of human rights ideas. Subsequently and in parallel, tribunals can also try to do where in the interpretation and application of these treaties. So what does our framework try to do? Our framework tries to give guidance in addressing three key challenges. On the one hand, strengthening the development dimension. And that for UNCTAD also very much has to do with the issue of protecting policy space. And I think here again, the guiding principles come in nicely with this one article talking about policy space and the need to preserve policy space for governments to fulfill their human rights obligations. So in the guidance that our framework gives with respect to that issue, I think here guiding principles and our framework work very well together. A second area for our framework for international investment policies is the need to rebalance the rights and obligations between governments and businesses and foreign investors. And I think that's maybe an issue the panel has not yet flagged, and I would like to raise that for debate also by the audience here. International investment treaties usually give rights to investors and obligations to governments, and that's the way how it used to be. And there are many valid reasons for why it was this way and why it is this way. But there is a very big question whether there isn't need for a bit of rebalancing. And our framework recognizes this question about rebalancing and tries to give some specific ideas of what can be done. And I think here we can also link it back nicely to what the ICC guidelines say, namely that companies really have to respect domestic laws and regulations at a national level. Thirdly, our investment policy framework talks about managing the systemic complexity. And that's, I think, again, bringing us back to what Zachary mentioned. Like, how do we kind of like bring human rights back home to investment? How do we talk about different bodies of law and how do we make sure that they work coherently. And I think that's also part of the guiding principles, this very important idea of ensuring coherence between different areas of policymaking, different areas of law at the international and national level. So by addressing three main challenges, namely how to strengthen the development dimension, the policy space issue, how to rebalance rights and obligations, companies' obligations to also respect human rights, and how to manage the systemic complexity of the international framework with respect to international investment. That's the issue of coherence between human rights and international investment law. By addressing these three issues, our policy framework, I think, really is an opportune tool for investment treaty negotiators, the type of people Renato talked about, when it comes to designing new treaties. I do believe that the guiding principles can also play an important role here. I have already emphasized the Article 8 on policy coherence, which matches very well with the ideas being put forward by UNCTAD. I've already mentioned Article 9 on policy space, which, as I mentioned, very well matches with some of the ideas being put forward by UNCTAD. And I think together they really offer some set of tools for different stakeholders to start thinking about the way forward. And I think I'll try to stop it here. By emphasizing again the storyline that indeed foreign direct investment, TNCs, have an important role to play when it comes to fostering sustainable development, and human rights is part and parcel of that. Secondly, when it comes to negotiating new international investment in treaties, reforming existing ones, both the UNCTAD framework and the guiding principles can be a useful toolkit. And thirdly, an open question how we can make it easier for these international investment tribunals interpreting these 500 and plus cases to consider human rights arguments in their deliberations. And I think here that's an area where academia and policymakers still also have some interesting steps to pursue. Thank you, Andrea.
Thank you, Elisabeth, and I have to thank all of our panelists and commentators for being so good with the time, because that facilitates my work enormously. And also thank you for sharing the very interesting experiences and also for the very apposite remarks from our commentators. And before I open the floor for questions from the audience, I'd like to briefly remind us of the our ground rules. The first one is then to please use the designated microphones for the different categories of stakeholders that are here in front. So we have the state, civil society, and businesses to my right. Second, please state your name and your affiliation clearly before your intervention. And finally, please limit your intervention to 2 minutes so that we can hear from as many of you as possible. And please remember to avoid the prepared written statements. And then with this, I invite you to contribute.
My question to the panel is about, while the policy on investments is talking about protecting the investor, I do not see where human rights are protected clearly enough. And the case that was brought up in these very rooms about 3 weeks ago was where one corporation is suing one country for $1.3 billion. And that's an infringement, obviously, on the human rights of the people in that country, because that country is not a wealthy country. So there's a serious need that whatever arbitration and jurisprudence evolves from these things, that human rights are always protected, and the ability of the country to protect its people's human rights must be given priority. So my question is to the panel about how that can happen. Thank you.
Thank you. Now this issue is of importance to us because if the problem of capacity and power of the businesses, well, that can be opposed to the weakness of the state when we talk about investment contracts. Such inequality means that states are incapable of negotiating, and as you've just said, quite often they're not even aware of the substance of what's going on. And this has an enormous impact everywhere on political stability in countries, and the majority of crises that we've had in Africa are linked to resources. Now, although there are resources that are considered almost, well, indeed, we have a lot of oil, for example, but you're going to have conflict. If you've got uranium, you'll have conflict as well, so they're not necessarily beneficial. So there's also an impact in terms of human rights with regard to exporting products like gold, and that has an impact too on the environment. And when you have resources in a country, in reality, you're almost losing everything. So the human rights impact is, for us, really quite rare, with the exception of Botswana, for example. Now, we do have guiding principles, but from my point of view, they're very weak, very ambiguous. The notion of social responsibility, for example, of businesses, in fact, there's no legally binding aspect of that, linking this concretely to what has to be done. Now, from my point of view, it's as if we were moving on to another post-colonial century, if you like. There is a continuity. Thank you.
Thank you.
Now, just to say, I'm the president of the National Human Rights Commission in Senegal.
This clarification, I was going to ask you to please identify yourself, but thank you for doing so. Again, I'm trying to see if there is anyone from the state or the businesses that would like to make a comment or a question for our panel.
Buenos días a todos.
Good morning, everyone. My name is Nicholas Duran. I work with the Human Rights Presidency in Colombia. And now I just wanted to make a comment with regard to the process that's going on in Colombia. I think it's very important. It's a very relevant issue, so thanks to the panelists for their interventions. Now, for us in Colombia, in terms of a human rights program, we're undertaking a process with the commercial sector in order to have a discussion with that sector, in order to try to harmonize the language that we have in terms of human rights. And so we're very grateful for the Minister of Trade and Industry, because currently, if you compare today with 5 or 10 years ago, we've made much progress with regard to the commitment that the trading sector has to human rights. And we have raised awareness in this sector, as our colleague from Ecuador said. We're trying to talk the same language, really, and try to have a human rights-based approach when we look to create trade policies. And currently, the public sector is undertaking a social responsibility policy in line with human rights that will work in the years to come, from 2014 to 2015. And this is very relevant when we try to negotiate investment treaties and contracts, and also, of course, with regard to trade activity as a whole and financial activity and investment too. Now, finally, I'd like to thank you for the opportunity. And just a general question for all panelists could be, currently, what progress do you see in terms of the dialogue between the investment sector and the public sector with regard to human rights? Is there a balance here, percentage-wise? Do you think that states are creating dialogue on these issues? Well, I do share your opinion. Now, although the issue is being addressed by the General Prosecutor, the Attorney General, well, and also is being dealt with by the Republic, I think nevertheless these are issues that address us all. That's to say that international law, with how it bears on investment and instruments, is very complex and sophisticated, and there are quite often protection standards involved. And much work is done in terms of jurisdiction and justice negotiation, but independently from this, in terms of all the legal resources and measures and substantial issues that are provided. You know, in this case, for example, if there's a company that has contaminated a region in eastern Ecuador, now the people here went to the company, and what happened was that the state might be able to look at the possibility of compensation in the line of millions of dollars. Now, in fact, who's dealing with this issue is the Attorney General of the Ecuadorian state. Now, with regard to whether we're using the guiding principles with businesses, well, undoubtedly this is the idea, but there are two examples here. Now, it's important, firstly, in the short term, whether these can be used already and immediately. For example, in investment contracts, we're trying to include clauses which will give rise to technology transfer, despite the fact that we don't have legislation that demands this. Nevertheless, we can work on secondary standards in terms of regulation and agreements, and we can also work on agreements with the private sector. So I don't think we necessarily need legislation which would require that a legally binding treaty be signed. This can already be implemented, I think, straight away. And of course, the commitment of our country is to do so as quickly as we can, at least with regard to investment. But despite this, I think that we also have to work on the long-term aspects, so that in a not-too-distant future, perhaps we might be able to work towards a multilateral, legally binding instrument, such as a treaty, for example. Now, we know that this would be a much more complex project and might take a long time, but the first step has already been made by Ecuador, and that's to raise the issue for discussion in the international arena.
I'd like to react to some of the questions.
Yes.
Thank you.
Thank you, Andrea. I do agree to the extent of what Samuel said, that sometimes if you don't address these issues in a contract, then you create a dangerous vacuum. And that's why ICC, with its investment guidelines, we call on investors to integrate human rights and corporate responsibility and anti-corruption considerations in international investment agreements. And I think I do want to say that, and maybe it's also the approach that Professor Ruggie took in the development of the guiding principles, was a very inclusive, consultative approach in the, 5, 6 or more years that he took with his team to develop the principles. The reason he has businesses on board, the reason that we are committed to respect our corporate responsibility along with the guiding principles, is because of the approach that Professor Ruggie took in terms of taking into consideration the different factors of businesses, that there's no one size fits all and so forth. And that meant very much by business, and that's why you have, generally speaking, the business uptake and goodwill on this. And I'm not sure that you would have that if efforts were made for a legally binding instrument. Je suis sensible à ce qui a été.
Now, I'm sensitive also to and aware of what's said by the head of the Human Rights Organization in Senegal. And I do understand that sometimes you do need constraints in terms of creating obligations. I don't know whether businesses would have such a willingness, or indeed the desire themselves, to conform, to come into line, and indeed take on these responsibilities. Now, I don't know whether this is the way, or indeed, I would say the most effective way. Perhaps that's the right word. It's a bit businesslike, but nevertheless, the most efficient or effective way to get what we want. But I am aware of what you said. Of course, natural resources are important, and I do recognize that reality. So there we are. I'll stop there.
Professor Douglas?
Microphone, please, for the speaker. Microphone, please.
How to operationalize human rights within an investment treaty context. Take one example of the International Law Commission's articles on state responsibility. They are applied as if they are hard and fast law, as if they are precise reflections of customary international law. And yet, of course, as you all know, the ILC's draft articles do not have the status of binding international conventional law in any sense. When tribunals come to interpret something as amorphous as fair and equitable treatment, they have to rely on extraneous sources. What the investors have managed to put on the agenda in this interpretation is a concept of legitimate expectations, and it's borrowed they say to some extent, from administrative law, comparative administrative law. The difficulty with this transplant is that in comparative administrative law, if you say that, if you manage to succeed in demonstrating that there's been a breach of your legitimate expectation, then the remedy is that the decision maker has to render a new decision. The remedy is not that you get full compensation based upon a discount cash flow analysis over the lifetime of the investment project. Now, where's on the other side of the coin, what are the states saying is the content of the fair and equitable standard of treatment in a similar way? And this is the difficulty. There is no statement. There are no studies which are undertaken to try to give concrete meaning to these types of amorphous obligations. There's no reason why something like the Harvard draft articles or the ILC's articles on state responsibility could not be drafted in a soft law way, if you want to use that expression, in order to give greater content to a standard of that nature. Whether or not a multilateral treaty may solve all the problems, perhaps it would. From my perspective, that looks a little bit utopian as things stand. I'm more concerned with how to resolve the 501 cases that are now pending. And it seems to me there is enormous potential for various stakeholders to get involved in a draft concept paper, a draft set of articles, something of that nature, which lends itself to judicial application, which descends from the lofty heights of abstract principles and demonstrates how human rights can be operationalized in this context. It doesn't need the force of law, because most of the sources that are relied upon to interpret these standards don't have the formal source of law. It's just a case of balancing the various sources that are currently available. Another statement was made about the amounts in dispute and how this can cause an extreme burden, especially upon developing states. It is undoubtedly the case that the sums involved in these cases are massive. The Czech Republic lost a case and had to pay the equivalent of its annual health budget in compensation. I'm representing the state of Ecuador in a case which until recently was quantified at $18 billion. The stakes are enormous. Again, you're going to think I have only one point, and that is the devil is in the detail. At the moment, the principles that guide compensation in these cases can be reduced to a single paragraph which says something along the lines of that any compensation must wipe out the consequences of an unlawful act. That comes from a case that was decided in the 1920s. According to the vast majority of tribunals, the law runs out there. The law says nothing further about it. So at that point, we hand over to the valuation experts, and they use valuation techniques which they would use to value a target company in a mergers and acquisition scenario. Is that approach legitimate in a situation where the state has endeavored to pass regulatory measures in the public interest? We could have a very interesting debate about that. Compare that approach to the approach of the European Court of Human Rights, who uses a concept of proportionality in determining the amount of compensation. That does not happen in investment treaty arbitration. As I say, all these points are substantive points, they are detailed points, they are subtle points, but there needs to be further work in these areas by a larger range of stakeholders. It can't just be counsel in these investment treaty arbitrations.
Thank you. I will ask rapidly Elisabeth and Samuel if they have some comments, because I'd like to take another round of questions from the audience. Thank you.
Okay, briefly. I start with the first question. I think two questions were addressed to me. You were totally right that our 11 principles don't mention human rights per se. However, we didn't invent the principles. We make clear in our document that when we developed our 11 principles for investment policy making, we draw on a lot of existing material. We draw on the Universal Declaration, on the MDGs, on the Johannesburg Plan of Action. We also specifically draw on the UN Guiding Principles on human rights. And we were very pleased that one of the current working group members was actually part of our experts who we worked with when developing our framework. So you're right insofar as that the word human rights doesn't show up in the principles, but when we're explaining where we source them from, it shows up very strongly there. Secondly, when you look at our principles, I think so many of them are related to human rights. We talk about investment for sustainable development. Clearly, human rights has a role to play. We talk about policy coherence. That's your Article 8 in the guiding principles. We talk about public governance and institutions, the whole idea of making sure that multi-stakeholder, interdisciplinary approach when developing your investment laws and regulations. We talk about dynamic policy making, the need to adjust to changing circumstances, like, for example, the existing of the guidance principles. We talk about the balance between rights and obligations. We talk about the right to regulate and about international cooperation. So I think many of our core principles address issues that are fundamentally important and coherent with human rights as well. The second question from the first person from the floor related to this point of rebalancing investment agreements. And again, I think the point was made that it's true. Most of the current more than 3,000 international investment agreements, all of them establish rights for investors and obligations for companies, and obligations for countries, sorry. And what we try to do in our framework is start thinking about this rebalancing. And I really invite you to look at Section 7 of our framework. And that's where we worked very intensively with people from the Working Group on Business and Human Rights and with a wide range of stakeholders, including academic experts, trying to see how can we make these IRAs a bit more balanced. Then we have a series of options there. And I think that brings me now also to the point mentioned by our colleague from Colombia, that it is very important in the drafting of these treaties that you take a human rights approach, or that you take some sort of like human rights ideas, and that you need to bring these different stakeholders, entities, policymakers together. And I think, again, UNCTAD is trying to do that. For example, in our regional training course, the last one of which we held in Colombia, but the one before we held in Bosnia, we were pleased to have a member of the working group to present the guiding principles and to have a staff member of the Office of the High Commission on Human Rights, notably on the right to development, to participate in our workshop to share their ideas so that we can start building bridges between the investment policymakers, the typical stakeholders of our courses, and human rights experts. Because, as you rightly mentioned, we need to start talking a language that we mutually understand. And I think that's really where a lot of the future action should lie. What we also try to do, and I think you ask us to see how far has the discourse evolved here, we try to map the existing international investment agreements and the ones that are being concluded every year according to how many innovative features they have. And I have to say that indeed most of the typical bits don't have innovative features on human rights, but some of the free trade agreements, which frequently also contain an investment chapter, there you can see initial starting points. And I think that's, again, an area to build on. Our World Investment Report gives you some tables, statistics on that, and I invite policymakers to look into that evolving area and carry it forward.
Thank you. I'd like to have one quick comment on what was said by our Senegalese colleague. I fully agree with what you said. Most of the countries in Africa face conflict because of natural resources. And I want to link this back to the contracts we are discussing and to the human rights obligations of the state. Human rights are considered as being imperative norms, jus cogens. Everybody is obliged to comply with that. And if the state, because of the contract with an investor, is not able to fully comply with its obligation, the international justice will not take that as an excuse. The state will be, the rulers will have to face justice. So I really think this is a paradox here. There's a very clear paradox. The way international law considers states' obligation and companies' obligation and looks at the contract, I think there is a kind of paradox there. The rule is there and is very clearly stated as being on top of every other rule in international law, part of, I don't know the English word for that, but jus cogens.
It is.
Sorry? Okay, exactly. So this is an obligation of the state, but this cannot be used for the state to prevent himself to fully comply with his obligation on the grounds of an investment contract. And I think this is a paradox, and this, I think, has to be looked through, especially in the context of countries where we have a lot of conflict and lots of massive human rights violations, exactly because of the management of those resources.
Thank you. I'll take just a couple of questions more, and again, I'll start with the state. Is anyone from the state? No one? From, let's see, yes, please. Okay, please.
Thank you. I'm actually not representing a state, but the United Nations Environment Programme Finance Initiative, which is a partnership between the UN and the finance sector, working for the integration of environmental and social issues in the operations of finance. And I would like to make a very brief comment, because when we work with finance institutions, we work towards commitment that goes beyond legal compliance. And a lot of the panel's discussion was naturally focused on legal obligations and the balancing also between obligations of states, and rights of investors. But I think what was missing maybe in the discussion was the mentioning of due diligence and the benefits for investors to actually mitigate and address human rights. And I think that is a very, very important piece that should be, included in the discussion, and also the alignment between international guidance that helps investors to look at these issues should make a very clear business case for investors to integrate human rights considerations in their policies and not leave everything only to treaties. So there is a broader discussion on that, on actually the benefits of investors to and financial materiality of human rights risks. Thank you.
Currently, there are several states which are interested on revising some features of the current state investor arbitration system. Which would be, in your view, the priorities? Because I think the question of transparency already arose. So which would be the priorities, according to your view, the things that should be touched on? Thank you.
I'm Peter Frankenthal of Amnesty International UK. Just a follow-up to that. Can the panelists envisage a time where all state investor contracts will automatically be in the public domain, both as a means of minimizing the prospects of corruption, but also ensuring that these contracts are more equitable through the knowledge that they'll be subject subsequently to public and parliamentary scrutiny? Would that be a good way of rebalancing private and public interest, having these contracts in the public domain?
Thank you very much. Since we only have a couple of minutes left before the end of the panel, I'll ask the panelists who would like to answer these three, the comment and then the two questions.
Yeah.
Viviane and probably Elisabeth? Okay.
Thank you, Andrea. Just for the comment from the representative of a UN agency, I don't know, perhaps you weren't there when I spoke in the beginning. I represent the International Chamber of Commerce, and actually, obviously the private sector and businesses and banks, and with our ICC guidelines for investment, international investment, as I mentioned before, the guidelines incorporate the guiding principles of RUGI for business and human rights, and our ICC guidelines call on investors, private investors, to use due diligence in selecting and working with business partners to establish governance systems and clear lines of accountability, to implement corporate responsibility goals and to communicate the results externally, to respect the human rights of those affected by their activities, and to engage with relevant stakeholders and consider their views. I mean, obviously, as I represent business, I'm not in a position to talk about treaties. I'm in a position to talk about what companies and banks and investment firms can do in terms of their corporate responsibility to respect human rights. And due diligence is obviously a core part of our corporate responsibility to respect. Thank you.
Thank you, Viviane. And I think Elisabeth wanted to.
Yes, definitely due diligence is also important for us. We do have it in our framework, and I do believe that due diligence maybe also is the concept that can us bring a step closer when it comes to interpreting certain things, like, for example, the FET obligations Zachary talked about. ISDS, investor-state dispute settlement, and the need for transparency, what is the most important issue for reform. I wouldn't want to rank them, but I point you to, in this document here, we have outlined 5 paths of reform, how to reform investor-state dispute settlement, building on the fact that many governments at the moment are looking into reform. Transparency definitely is in there, but it's not the only one. There is some more work that remains to be done. Thank you.
I've just been told that we need to close the session, but I think it's just perfectly on time because we've addressed the questions that were raised. I'd like to thank our panelists, our commentators. I'd like to thank the audience for the very interesting question and questions that were raised. And I think that we leave the room with the feeling that the work in the investment area is just beginning, that there is a lot of work to be done in terms of dissemination of the guiding principles and the principles for responsible contracts. There is also a lot of work to do in terms of the practical application, and I think that one area that deserves special attention is then how to facilitate the judicial application of human rights issues in the context of investment dispute resolution. So thank you very much to all of you.